SJC-11989, Commonwealth v. Joshua Edwards.
Mr. Sears, one moment.
Good morning.
Why don't you wait until Mr. Keneally is finished? Mr. Johnson's arguing first. Ah, okay. Gotcha. Turns out you're actually Mr. Johnson. Sorry about that.
No
Okay.
problem, Your Honor. Good morning again. My name is Greg Johnson. I represent the appellee defendant in this matter. This is a case that started with a motion to suppress that was allowed by Judge Salinger at the Suffolk County Superior Court. The Commonwealth took an interlocutory appeal, which then led to the reversal of the motion judge's ruling. I filed a petition for further appellate review, which brings us here today. The defendant appellee's argument for the court is that the motion judge was accurate and correct in his ruling that the police did not have sufficient facts which should amount to reasonable suspicion at the time they stopped the motor vehicle that my client was riding in on the date of the incident, which is about 3.5 years ago. The police on the date in question received a 911 call from a named caller, an individual with the last name of Watley. That person told the police, or the call taker, that there was a man with a gun on the street, and then he got back into the car and brought the gun back with him into the motor vehicle. Now, the caller was speaking with a heavy accent, and it was very difficult to discern the exact sequence of events, but there was information that the motion judge found that the defendant in this case did at some point leave in his motor vehicle and then at some point return to the scene where the police later found him.
Was the tape in evidence?
Yes. Yes, the 911 call and the subsequent police radio transmissions were admitted at the hearing and then also at the lower court appeals hearing.
And did Mr. Watley, is that the name?
Yes.
Did he say the car had left and come back, or I forget how that finding was made?
Yes, the caller to 911, it's unclear which Watley was exactly the caller. The motion judge found that it was a Jabari Watley, who was also the individual that was outside the home when the police officer arrived. However, when the caller identified him or herself, it's difficult to even tell the gender, they used the name of Junior or Judith. So there are two different names that were given, or two different individuals, as far as I can tell, that were involved here. So the caller was very difficult to understand in terms of the exact order by which the person got out of the car, got back into the car, and when they left and how long they were gone, which goes to my argument about the specific argument that the Commonwealth made and the appeals court found was that the defendant was circling the area, which I took great exception to and pointed it out in the first section of my brief. There was absolutely no evidence other than leaving and coming back after an unknown period of time that led to...
Well, he leaves, when he first is observed, he's holding a handgun. He tosses the handgun in the vehicle, leaves, comes back, and then he's seen displaying the handgun for a second time, correct?
That's not my understanding at all. My read of the motion judge's ruling and also my listening to the 911 call that was admitted, there's only one occasion where the individual got out of the car with the gun in his hand. There is no clear evidence that he got out of the gun on two separate occasions with that weapon in hand. And I think that's a critical part of the analysis, because all we have here is a report of a man holding a weapon on a street with nobody else around. This is 1:30 in the morning on Army.
Did you say what kind of gun it was?
My memory is that he did not. They may have said handgun, but I don't want to.
It wasn't like he's got a shotgun.
No. That was not what the caller said.
So what is a police officer to do? He has strong reason to think that somebody has walked out of a car holding a gun, then returned to the car, is sitting in the car with the lights off, the engine not on. It's 1:30 in the morning. What's a police officer supposed to do?
To pull up down the street and park, not blocking the motor vehicle in, as the officer did in this case with his blue lights flashing, nose in, so that my client's car wasn't going to be able to go anywhere, even if he had attempted to park the motor vehicle and approach and investigate what's going on, to figure out whether this person poses any threat to public safety whatsoever.
But don't the brake lights go on before he's blocked?
They pull, yes, they do. The lights illuminate, my memory, the transcript and the hearing as the car is approaching, as the police car is approaching my client's motor vehicle. And I think that the Commonwealth went to great lengths to argue that this was precipitous flight, and this was obvious evidence of my client trying to flee the scene. I think that's a reach at best. Just because somebody puts their foot on the brake pedal does not mean that that car is then going to be started with the key and then pull out from a parallel parking spot along the side of the curb.
Does it matter that even though it appears that the 911 caller didn't use or suggest circling behavior, that the dispatcher did? He's the one or she's the one who said that the defendant was circling. But that's what the police officer heard, right?
Yes,
So does it
and-
matter that that's what the police officer knew at the time he approached?
Well, I think
your
the collective
client?
knowledge doctrine would apply here, and then the police as a whole have this base of information that does not support the conclusion that the individual is circling, that the dispatcher, the call taker, the untrained individual who's relaying the information to the patrol officer is characterizing it in a way that the facts don't support.
Well, that's fair enough, for sure, but he left, went down, is it Armandine Street?
Armandine Street,
Armandine
yes.
Street, and came back shortly afterwards. And just like the brake lights going on, that's not circling, that's not making the block, but it's a pebble of something beside a gun out at 1:30 in the morning, isn't it?
I think a pebble is a good way to characterize it, Your Honor. It is certainly not sufficient evidence to tip the scale in a close case from no reasonable suspicion to reasonable suspicion. I can't stand before you and argue that the person, they didn't have information that he left the scene. I concede that he did leave.
If the facts are that he had the gun in his hand the first time, leaves and comes back the second time, I know you dispute that, but if those are the facts, that he's observed twice with the gun in his hand, isn't it a reasonable inference that late at night he's looking for someone? You don't take
I don't think we can.
a gun
leap to
isn't a
the-
dog. You don't take a gun for a walk, right?
I'm sorry, I missed the
A
beginning
gun
part of that
isn't a
question.
dog. You don't take a
Right.
gun for a walk, right?
I'd agree, yes.
So what's the reasonable inference if someone sees someone carrying a gun twice in a short time span?
That the person is a licensed firearm holder, that they're bringing the weapon from the motor vehicle to the place that they're going to, whether it be a house on the street or back into the motor vehicle and leaving the scene, as my client did.
But, well, can I go back to Chief Justice Gance's
Please.
question? So you say he couldn't, okay, the police officer stops, talks to one Watley or another, starts, the brake lights are on. You say he should have walked up? What if the car goes, can he follow it?
Walk up, drive up alongside so that the car is not blocked in,
Right.
not respond with a display of force
All
that
right,
the
but
officer
let's say
did in
he
this
doesn't turn
instance.
on his blue lights. He just drives up alongside and opens his window. And he says, "Can I talk to you?" And the car zooms off. Can he follow it? Or
In this case, the car didn't have the ability to zoom off because there were pictures
say
that were
this,
admitted.
I'm just trying to figure out what should he have done? Because do you disagree that it would be not unreasonable for the police officer at least to be able to question? I know there's a stop, but let's just say, forget the car. Man's on the street. The neighbor has seen him come out of his house with the gun and go back in, and then come out again. So the police officer walks up and says, "Can I ask you some questions?" That's not this case, but the guy's in the car. What is he supposed to do, the police officer? If given where it is and at night, he wants to ask a question.
My argument is that he should walk up to the motor vehicle, something akin to a field investigation, interview, something that does not amount to a stop, as what happened here.
With gun drawn or with gun in holster?
In holster. There's
But you're
no way
asking,
that-
you're asking a police officer to confront an armed man sitting there at 1:30 in the morning. I mean, is that something fair for us to do? To ask a police officer to keep, under those circumstances, to be confronting that individual without knowing what he or she is going to face?
I know that it's a fine line, and it's a delicate balance, and it's impossible for me or anybody else to put ourselves into the shoes of the officer that's going to be making that approach. But when we're dealing with a situation when the response by the police was over and above what I think the officer could have done, that's when the court is thrust into the position where they have to analyze whether there's reasonable suspicion to act in the way that they did. So we only have the facts as they unfolded. I think that there are other ways that the officer could have carried himself to approach Mr. Edwards on the date in question.
And one last, at least one, from me, a last question. Reasonable suspicion if the police officer had reason to believe the gun was not licensed, and reasonable suspicion to believe, to stop if the police believed that he was, as Justice Gaziano said, looking for somebody or planning some violent crime. Do you add up those two probabilities to evaluate reasonable suspicion?
No, I think they're separate. I think that if there's reasonable suspicion that the individual is unlicensed, then that really is probable cause, and an arrest can be made immediately. So I don't think that there was any evidence here that the individual was carrying an unlicensed firearm. There was nothing. There was discussion of a holster, and that the weapon by my client should have been holstered at the time. I think that the motion judge got it wrong in his findings of fact, where he stated that most or a number of licensed firearms individuals carry their weapon in a holster. If you
Isn't
look
that
at
what the officer testified to
No,
in his experience? No?
It's not. If you look at page 40 of the transcript, that when he's asked about that, it said that the prosecutor asked, in your both realms, so to speak, what is your knowledge in terms of how people typically licensed carry? People who have a license to carry typically carry them. And I know that wording is off. That's the way the question reads on the transcript. And then the officer responded, the responsible way to carry a firearm is in a holster. So he's not characterizing it as most people carry their guns in holsters. I think that a layperson could come to the same conclusion, that people don't carry them
Didn't the
in
911
holsters.
caller also say he tossed the firearm in the vehicle?
Yes.
Is that an action consistent with the licensed firearm holder?
Well, I think that there are many different definitions of toss. Is that somebody just putting the gun back on the seat and closing the door and locking the motor vehicle? I think, obviously
Is
where
it
the
one
court's
supposed
going
to
with this.
secure a fire? Are you supposed to secure a firearm in a vehicle?
Yes. But that also, with regard to the toss, the caller also said that the person got back into the vehicle with the weapon. At no point was there any evidence that my client was outside the vehicle without the gun.
So the issue clearly is that he has a gun is not enough, that he didn't circle the block, that he left and came back isn't enough. The question is, considering all the circumstances that have been alluded to here, whether or not it's enough for reasonable articulable suspicion. And you're saying it isn't. But if it is, if there is constitutional justification for the seizure, you seem to be arguing something that's not in your brief, which is the scope, the manner in which the seizure occurred was more than the constitutional justification.
No,
Then if it isn't, then he had no other choice but to go up the way and pursue the way he did. If you don't have a scope argument, going back to Chief Justice Gantz's points, if there's no scope argument, he used the only alternative he had.
Yes, and I think that the analysis here is pretty narrow. It's whether there was reasonable suspicion to stop my client. So I hope that answers the court's question.
In fairness, that answer was in response to what could the police officer have done, what you said about what he should have done.
Yes, thank you.
Okay. Fairness.
She's always fair, always. Thank you.
I appreciate that to close. Thank you, Your Honors.
Thank you.
And now, Mr. Sears.
Good morning, Honors. Matt Steers on behalf of the Commonwealth. In this case, there are two constitutional grounds for the stop, and I'll start with the first one, which is commonly recognized reasonable suspicion of criminal activity. In the judge's specific express findings and in the 911 tape, which I moved to transmit to this court, so this court should be able to listen to it, a 911 tape that was received without qualification, without limitation, there are no fewer than 6 factors, analytical factors that support reasonable suspicion of criminal activity. First is gun possession in and of itself, aside from any accusation of unlawful gun possession. Where there is a gun, that is a factor to be considered. That's in Stout, that's in Haskell. Second, the manner of the gun possession. As Justice Gaziano alluded to, the 911 caller testifies that after the defendant got out of his car holding the gun in his hand, he threw the gun back into the car.
But didn't he just get back in right after that?
He got back in right after that, but I think the manner of possession of the weapon shows an irresponsibility.
Okay.
Well,
And
then
I'm
that
sorry,
brings me to the third.
and the irresponsibility permits an inference of what?
The irresponsibility when read with his behavior, his suspicious behavior, the third point's supporting reasonable suspicion.
Isn't reckless conduct with a firearm not enough?
For a stop, I believe it is. It's enough for a stop. But I think we have this reckless conduct bookended by suspicious activity. So whether or not there's circling behavior or not circling behavior, in the 911 call, there's a known concerned citizen who reports that he's driving around the block. He says around twice. 2 arounds seem to me to support a circling. But putting circling aside, we have behavior where, and this is again in the 911 tape, the call indicates he drove around, exited his car with a gun in his hand in the street, threw the gun back into the car, entered the car, drove around again, and returned to the scene. And the returning to the scene is when the officer identifies him, when Jabari Watley comes running out of his house, shouting, "There he is, that's the guy." So we also have the demeanor of this concerned citizen to reflect on the dangerousness and the suspicious behavior.
The record's silent as to whether or not anybody else was out on the street.
Correct.
In Haskell, there was a bar he was loading the gun in front of, correct?
That's
You
correct.
don't have any identifiable victims.
That's correct. Well, from one person's point of view. I mean, I just don't know that we also don't have the concerned citizen on the ground looking around, identifying all individuals. Be that as may.
I'm sorry, before you leave the demeanor of the concerned citizen,
Yes.
he didn't see anything other than what he said. So what inference could be, I mean, it would probably be upsetting for somebody to see somebody carrying a gun, licensed or otherwise. What do we do with, what's a judge supposed to do with that?
Well, again, you'll be able to listen to the 911 tape. I would argue that he's excessively agitated. He doesn't respond to 2 of the 3 questions of, is he threatening you? The 911 operator has to bring him back to answer these questions.
And what does he say in response to, is he threatening you?
At the end, he says no. And then she says, does he have problems with anyone else? And he says, I don't know what to tell you. So I want to speed forward because I want to get to my second justification for this.
We'll give you 5 and 6, go ahead.
Okay, thanks. The fourth is the 1:30 in the morning. Late night is a recognized analytical factor for reasonable suspicion analysis. The 5th factor is that this is a violent gun crime area. And this is not an empty distinction here. We're not just saying high crime. The judge himself recognized that the officer knew of gun violence in the area. He knew of specific shootings, shots fired, people being injured, homicides, and even officers being shot. And then the 6th analytical factor is flight. And I know the judge himself, motion judge, did not find flight, but he made specific factual findings that would support the inference of flight.
Now, wait a minute.
Doesn't the judge also just really limit the extent to which he says he credits the police officer's testimony?
He credits the police officer's testimony. So this is problematic, but I don't want to spend too much time on it. He says, I credit the police officer, and I credit his testimony to the extent that it is consistent with.
And reflected in express findings stated in this memorandum.
Correct, but he does.
And that's the only, I mean, he really limits the extent to which he credits the police officer's testimony.
Right, but
So why should we take into account things that he did not?
Well, he credits that the light came on in the vehicle after Jabari Watley came running out of his house, and said, that's him, that's the guy, and after the officer had driven up the street. Those are the factual findings.
But you're suggesting that we should draw an inference of flight? How could we possibly do that?
It's a reasonable inference, and I don't know that you need to draw
We're
that
not the
inference.
fact finders.
I don't know that you need to draw that inference, but that was an inference that is fair that the officer himself made, and we're looking at this through the lens of this officer on the case.
So on your theory, we can also take into account that the officer had heard the dispatch, but not the original 911 call, and that we can credit, or that we should take into account, that that's what the police officer knew?
Well, I think the collective knowledge doctrine imputes everything in the 911 call to the officer.
To the extent that that's contrary to what the dispatcher said, what do we do with that?
And respectfully, I don't think that there's anything
If
contrary.
there is an inconsistency, what do we do with it?
Well, I think you read whatever the 911 tape says
Okay.
as imputed to the police officer.
Well, I'm sorry, so the 911 operator is only relaying the information given by the caller.
Right.
If that person characterizes it as circling, and we say there's no basis to do that, how can we include that?
The 911 caller also says driving around the area. The 911 caller the call-out operator also says driving around the area. That is exactly what the 911 caller said twice. Been driving around, went down Armandine Street towards Dorchester School to come back around. That's what he's going to do. That's what the 911 operator says. So circling aside, we have this information, direct information from the 911 caller to the operator and then back to the officer. The second proposition is under what this court in Shotgun Alvarado has recognized as a reasonable suspicion of an imminent threat to public safety. And this is how I would articulate this justification for a stop. Where a known concerned citizen notifies police that a person is carrying a gun in public, officers may conduct a limited stop in order to ascertain the existence and the status of the gun. And that goes directly to Justice Botsford and Justice Gantz's question, what is an officer to do here? An officer, where he has information, again, from a known concerned citizen, a verifiable person, that someone is committing an inherently dangerous activity, and this court has identified that public carrying of a firearm is an inherently dangerous activity, Commonwealth versus Jones, 372 Mass at 405 and 406, an activity that is subject to a general prohibition, an activity that is highly regulated, an activity that is readily apparent what its implicit and inherent dangers are, that an officer has the ability, and in fact, this court and the appeals court have said over and over again, a duty to immediately investigate. What's the scope of that investigation? I think the scope of the investigation, as courts have talked about, is very limited, is a non-intrusive, it's proportional to the public safety, and that is to simply ask for a firearm license.
Is that what happened here?
It isn't, but we didn't get there because of the subsequent activity.
The subsequent activity being that the defendant left the vehicle.
He left the vehicle and he did not respond to the officer.
Did he need to?
Did he need to respond to the officer? Not necessarily.
And then what happens?
And then what happens is he turns, the officer follows him, he turns back around, moves quickly to the back of the car, and the officer then apprehends him.
In your view, can you detain to ask for a firearms license to carry?
Yes, Your Honor, and I think that's what we're...
Isn't that really the rub, whether or not anybody can ask, a police officer can ask any question they want?
Yeah.
The question really is, on a constitutional basis, is can they detain
Sure.
to ask for the license?
And that's what Shotgun Alvarado says you can do. Foster, interpreting Shotgun Alvarado, says that you can stop a car, even if there's no reasonable suspicion of criminal activity, if there's reasonable suspicion of an imminent threat to the public, even a car stop is permitted.
Doesn't Foster require there be, quote, display, unquote, of the firearm? And do you think this constitutes display in this situation?
So Foster doesn't define display. All Foster said was display. I don't think Foster requires a display. I think Foster, as we read it, as Shotgun Alvarado says, is that the mere possession of this firearm is dangerous enough to warrant the stop. And I think, again, the only thing that changed from handgun Alvarado to shotgun Alvarado is the reliability of the concerned citizen. It's not the nature of the gun. A handgun versus a sawed-off shotgun is a distinction without a difference. If you read Shotgun Alvarado, the court talks about the deadliness of the weapon, the concealability of the weapon, the fact that it's compact. Those are all characteristics that handguns have as well. This is not my bailiwick, but I would argue that shotgun spray at 100 yards is actually less fatal than a propelled bullet from a handgun. So the danger in carrying was recognized in Shotgun Alvarado. The only difference, and this goes to the reliability of the imminent threat, is the known, the knowledge and the reliability from the concerned citizen who informs police of this public hearing.
But are you saying then that the mere knowledge that somebody has a gun is sufficient to justify a stop because the possession of a gun by itself presents a threat to public safety?
Public carrying, exactly, precisely. In this court,
Public carrying meaning public display?
no, just carrying in public.
Isn't that couture?
No, it's not couture. So couture also is important because it was decided prior to the Alvarados. So couture is 1990, the Alvarados are 96 for handgun, 98 for shotgun. Those are the cases that recognize this second justification for the stop, the imminent threat to public safety. All couture is also a probable cause case that dealt with searching a car. All couture stands for, and it still is fine, it's distinguishable, but it's fine, is that report of a firearm alone is not enough for probable cause of unlawful possession of that firearm. We're moving, I think, from the unlawful nature of possessing a firearm to the safety, to questions of safety in the public carrying of the firearm.
All couture was somebody had a small firearm protruding from his back. That's a lot different than this case.
That's correct. And couture it ran through a quick Terry analysis. And again, the second justification is not Terry-based. Terry analysis, reasonable suspicion of criminal activity. Couture says him possessing a handgun does not give us an indication of criminal activity. And I think couture actually says he wasn't casing, he wasn't threatening, he wasn't doing anything like that. But again, couture is probable
Why isn't that
cause.
applicable here?
Well, it's not applicable for two reasons. One, it was before this court recognized that there is a basis for a stop where there's imminent threat to public safety. And two, because the reasonable suspicion of criminal activity analysis is not limited only to unlawful possession of a firearm, it's all criminal activity. And the court in couture made that distinction. I mean, it was at the end, it's pure dicta, it had no effect on the case. But they said, if there are other indicia of criminal activity, which we have here, we have 5 other ones, other than possession of a firearm, then potentially there would be reasonable suspicion for a stop or probable cause.
So I'm trying to think how far you plan to go. So
Yes.
2 o'clock in the afternoon, downtown Boston, somebody tells a police officer that that gentleman appears to be carrying a firearm.
Yes.
The person is over 21, so you can't make that inference. The police officer can then pull his weapon, stop the person and say, I'm stopping you because you're a potential imminent threat to public safety and I want to know whether you have a license?
He could stop him and ask for the license. This is contemplated by the legislature.
Stop him with a consensual encounter or stop him pursuant to a Terry stop?
It's different from a Terry stop.
Okay, well, let's stop, can detain him.
Can detain him. Can detain him briefly for limited purposes of asking for his firearm license or an FID card. This is contemplated in the statute. Chapter 140, Section 129C says if someone asks for a firearm, or if a police officer asks you for your firearm license, you have to present it. You have to procure it upon demand.
Doesn't say you can forcibly stop them to ask for it, though.
No, it doesn't, and that's why I didn't argue that it can. I'm just saying that supports the reasonableness of this limited intrusion, that the legislature has recognized this as reasonable. And I agree 100% with what you're saying, Justice Hines. This was brought up in Barros in a Justice, I think, Sossman's concurrence, was that this was potentially another constitutional justification for a stop. A statute doesn't trump the Constitution, so we have to find what's reasonable. The touchstone of Article 14 and the Fourth Amendment is what is reasonable. It is reasonable when you have a justified, a reliable report from a concerned citizen that someone is participating in what the legislature has called an imminently dangerous activity to, again, stop them, request a firearms license. There's no Miranda issue whatsoever in that. Haskell, the second part of Haskell, addresses that.
Would that chill the Second Amendment rights of people who are legitimately carrying a firearm to just be stopped
It
at
doesn't.
random on the street because the police officer decides that this might be a dangerous situation?
It doesn't. The Supreme Court has held that, in, I think, DC versus Heller, that a regulatory scheme is not unlawful chilling or it doesn't unlawfully impede on someone's right to carry a firearm.
What if the person who has been asked chooses not to answer? What happens next?
I don't know, and that might be for this court to decide someday, hopefully. I think there's a right not to answer. There's not a right not to present the firearm identification card. And again, that's the second part of Haskell discusses, that perhaps the officer, assuming that we have a custodial interrogation, assuming that a stop amounts to a detention akin to an arrest, that there could be a Miranda issue there. But that's not every Terry stop is akin to a custodial arrest. So the question can be asked, whether it's answered, and what the significance of that is, again, for later determination, not this case. However,
Except that here, the defendant walked away,
the defendant is walking away,
chose not to engage with the police officer at all.
right? And
And you're saying he wasn't really required to.
well, I don't think necessarily he is. He is required to submit his firearms license to the officer upon
Does he, under
request.
the statute, does he have to carry it with, the license with him at all times?
I believe so, yes. He has to present it. I mean, in the
Well,
statute,
does he have to carry, I mean, in other words, if he's on the street, does he have to have it in his pocket?
I believe so, yes. I mean, that's, I think it's implicit in the fact that you have to present it, that you are carrying it on
Well,
your
you could
person.
present it by saying, come by my house 3 hours from now and I'll give it to you.
And that's correct, and that's the solution that comes out of this. Again, this is a safety
But
solution.
here we have a seizure that has to be supported by reasonable suspicion, correct?
Reasonable suspicion of either criminal activity or immediate threat to public safety.
Right, there's no way around it. There's a seizure that has to be supported. It's not a consensual, we're not dealing with consent here.
No, I'm not talking about consent, and we're not talking about elevating some sort of consensual or limited stop to a pat down or a pat frisk. We're talking about exactly what Chief Justice Gantz asked, exactly what Justice Botsford asked. What do you do in these situations? What do you do where there is a report of someone carrying a firearm? This is a bright line rule that tells officers exactly how to act. When this court and when other courts, this court in Stout, and when other courts have directed that officers need to immediately reply to these incidences when someone reports a public carrying of a firearm. It fits squarely within Shotgun Alvarado, and it's already there. It's there for this court to simply recognize as that second.
But to make clear, the refusal to show the license to carry, not this case, it didn't get that far,
Correct.
or an FID card, that can't go into the calibration of constitutional justification because it's a statute.
I'm not saying that the refusal can be taken one way or the other. Here's what the refusal does. It puts a defendant on notice that there is someone, an officer, or someone has reported to an officer that he is publicly carrying a firearm. That diffuses any public danger there in and of itself to a degree. If a defendant says, yes, here's my firearm identification card, that also diffuses the danger to the public, because firearm identification card or a license to carry indicates that he's a responsible firearm carrier. If he says, no, I don't have either, here's my gun, it's at my house, I have 30 days to find it, bring it back to you so I can get my gun back, that also diffuses any danger to the public. What we're talking about here is not necessarily arresting people for unlawful behavior on this prong. What we're talking about is the imminent danger to public safety that publicly carrying a firearm has, and what officers can do. You don't necessarily need to determine this case based on that. I think it's there. Again, it's Shotgun Alvarado.
So the reasonable suspicion regarding criminal activity is what you say is supported by the six-factor analysis.
Absolutely.
You don't need a six-factor analysis for the second one?
No, it's important that for the second one, you have a known, reliable, concerned citizen, and that's what Shotgun Alvarado says. We have a known, reliable, concerned citizen
How
who
do we know
reports.
he's reliable? Because he
carrying-
gave his name?
Pardon?
He's reliable because he gave his name?
He did.
Is that what makes him reliable?
Well, he's reliable for a number of reasons. He gave his name. He gave very specific information about what was going on. He gave information about how he knew the defendant from when they were small back in Trinidad. He took a call back. Well, so the 911 operator called back. He didn't pick that up, but then he called 911 back again to confirm his phone his phone number. He came running and yelling down from his front step, pointing out the activity that he had reported. So I think that's sufficient for reliability. In Shotgun Alvarado, they found reliability based on the EMT's name, status, what he had seen, all other confirmatory factors.
I'm sorry, go ahead.
So Texas now has a new law effective that you're permitted openly to carry weapons in a public university. By your standard, under the U.S. Constitution, that means that they could stop any person who they see carrying a weapon on the University of Texas, Austin, and stop and detain them and demand that they show a license?
Yes, they certainly can ask for the production of a license. And I think in Massachusetts, where this court and this legislature have already articulated, recognized, and applied the fact that carrying a firearm in public is an inherently dangerous activity, that is a very minimal invasion, one that doesn't infringe on any constitutional rights, any personal liberties, that is I guess, directly proportional to
But when you throw a
the
guy
danger.
against I mean, what happened in this case factually, it's hard to, overkill is not an exaggeration, right? I mean, they throw him against the car, they put they get him on the ground,
Well, I would disagree with that categorization of overkill. I mean, both Haskell and Shotgun Alvarado say that even in a Terry stop, if officers feel threatened or if there's a report of a gun, that officers can draw their weapon, and as part of that stop, it doesn't turn it into an arrest. In terms of overkill, what you have is someone with all of those 6 factors already in the officer's mind, someone ignoring him and then moving quickly to the back of his car. I'm not sure what are they supposed to do? I don't want to be glib. I don't think that what the officer is supposed to do is to chase him around and around the car until something else happens, something else pops. So for him to run after him and tackle him is, I think,
But if he has no
sufficient.
obligation to answer the police officer's questions, how is it appropriate to do what they did?
So in reasonable suspicion of criminal activity, he already has justification for the stop. That's what supports constitutionally how he did what he did or what he did.
Okay,
But going back to Justice Botsford's point, is there a scope issue even if there's reasonable and articulable suspicion?
The lower court judge didn't reach the scope issue. I understand that the courts can affirm for any grounds, but there is no scope issue. And again, I guess I would just refer the court back to 2 sites in Shotgun Alvarado and Haskell. Haskell at 794, Shotgun Alvarado at 284 and 285, that talk about the scope of what an officer can do when there is a report of a firearm. And it includes drawing his firearm when making the investigatory stop.
all right, thank you.